out?
Yeah, that is exactly right. So they started the court proceedings a little bit late today. The entire thing went on for 4 minutes, but the judge sat down and immediately told all of us that there was actually a closed door in chambers hearing this morning ahead of the scheduled status conference. So she met with both sides. She met with the prosecution and the defense. And apparently, defense made a motion to continue or delay the preliminary hearing. Now, the judge indicated it was because of some kind of evidence that came out during the discovery process. She says, the judge says, the court decided there were grounds to continue this case, to delay it to July, but beyond that, we don't actually know what exactly in the evidence led to this. I imagine it might have something to do with just the amount of data. We talked about that last time, how the prosecution started uploading evidence from hard drives seized during the investigation, and days later, they were only about 10% through that upload process. What we were hearing was it was 40 plus terabytes of data, and that does include video evidence, photos of Celeste and the defendant. So I imagine
the water. It's raising the pressure. And according to prosecutors, that reservoir now includes forensic evidence, digital records, witness testimony, biological samples, and tens of terabytes of material still being reviewed. Before we go deeper into what the documents actually show, make sure you're subscribed to Audit the Case, because we don't just cover the story, we follow the evidence. Now, let's start with the simple question. What actually happened?
Going to be a few days. This is when the prosecution will present the evidence that they have. Maybe not all the evidence, but enough evidence to say, hey, judge, there's sufficient probable cause to support the charges and for this case to go to trial. That's what a preliminary hearing is. The defense has an opportunity to challenge the evidence. Now, I say that, but you're going to hear how the timeline got a little tricky.
On paper, almost nothing. The hearing lasted only minutes. No dramatic witness testimony, no cross-examination. No surprise confession, no major evidentiary ruling, just another delay. But sometimes a delay tells you more than a trial date. Because criminal cases are not measured by headlines, they're measured by discovery. And discovery is where this story becomes difficult to ignore. According to charging documents, prosecutors allege that David murdered 14-year-old Celeste Rivas Hernandez, concealed the crime, dismembered her remains, and took deliberate steps to prevent detection.
He's presumed innocent in the eyes of the law, but as a human being with a brain and the ability to think and perceive, I have to say this. This is not how I would expect an innocent person to direct his lawyers to act. If I were innocent and had been sitting in jail for months on charges I did not commit, I would be telling my very high-priced lawyers, no more delays, get me the bleep out of here. But that is not what is happening. Now, Julia,
of evidence to review. Follow the evidence. That phrase becomes important because when people hear delay, they often assume someone is buying time. Maybe. But in major criminal cases, delays often happen for a different reason. Volume. Too much evidence, not too little. According to public reporting surrounding the case, investigators allegedly recovered enormous quantities of digital material during the investigation. Photos, videos, electronic records, communications, data storage devices. The reported volume is
hearing in front of a judge. The defense has an opportunity to challenge this evidence, to hear what the prosecution has and to challenge it, see where the prosecution's going with their case. But we don't know how the defense is going to do it. And so going back to what you mentioned, whether or not this is an advantage for the defense, as somebody who's been covering this case for quite some time, I want to read you real quick what Steve Fisher posted on X today.
Staggering. Not pages, not boxes, terabytes. The kind of volume that can take legal teams weeks or months simply to organize. And that creates an unusual contradiction. The longer this process takes, the stronger some observers believe the prosecution's position may be becoming. Because every additional review potentially reveals new connections, new timelines, new corroboration, new context. Follow the evidence. Now consider another detail that emerged from reporting on the hearing. David reportedly appeared engaged.
We're talking about. He is so comfortable in front of cameras, in front of people on stages. He came in, he sat down in front of the judge like he owned that courtroom, and he started nodding and smiling at people. He didn't speak much. He just said, "Yes, Your Honor," to acknowledge her questions when she asked if he was okay with essentially delaying this case further. But he was very engaged, very active, making eye contact with the judge, nodding and smiling throughout. And this really caught my attention.
During the proceeding, on its face, that means nothing. Defendants are entitled to maintain their composure. They are presumed innocent, and courtroom demeanor is not evidence. But public perception operates differently, because outside the courtroom, people naturally compare two.
Delay is actually an advantage to David and his defense team.
I think there is so much evidence against the defendant here, Jesse. I don't really know if there's any kind of advantage for his case. I hate to let what's happening in the court of public opinion, leak into what's actually happening in the courtroom.
Competing narratives. The first narrative says prosecutors possess overwhelming evidence. The second says the defense continues requesting additional time before that evidence is tested publicly. Those narratives now exist side by side, and eventually they collide. That collision is what the preliminary hearing is supposed to provide. For anyone unfamiliar with
I'm going to give you a little preview. We were supposed to have a preliminary hearing on June 29th, and it's reportedly going to be a few days. This is when the prosecution will present the evidence that they have. Maybe not all the evidence, but
the process. A preliminary hearing is not a trial. It's not about guilt. It's not about innocence. It's about probable cause. In plain English, prosecutors must demonstrate enough evidence for the case to move forward. That's it. A lower threshold, but still an important one, because for the first time, portions of the evidence,
just the volume of data that still has to be sifted through, has something to do with the defense calling for this delay and the prosecution agreeing.
And look, what's difficult about it is we don't know what the defense is going to do. We don't know if their defense is going to challenge the timeline. We don't know if the defense is going to challenge the cause of death. But, there is a question of how much they're going to fight the allegations of this sexual abuse material allegedly found on his devices. And, maybe they need more time to form an argument. They need more time to prepare, because in a preliminary hearing, like we've talked about before, this case had gone to grand juries where it's one-sided. It's only the prosecution presenting evidence. No indictment was returned through that grand jury. So there was questions about why that was. But now it goes to a preliminary hearing.
Become visible. And that's where the unanswered questions begin. Prosecutors have described alleged forensic findings. They have described alleged digital evidence. They have described alleged communications. They have described alleged timelines. But descriptions are not demonstrations. At some point, evidence must move from
after this hearing. So Steve Fisher is a private investigator who's been looking into this case. He was hired by the owner of the property where David had reportedly been staying, a property that's reportedly near where that Tesla was recovered, with obviously Celeste's body allegedly found inside. So he wrote today, the preliminary hearing in the David case has been continued until July 21st. He is
to prove motive. How do they intend to prove intent? How do they intend to connect individual pieces of evidence into a single coherent narrative? Those questions remain open, and they matter because this case carries consequences far beyond another courtroom calendar entry. If prosecutors are correct, then this becomes a story about planning, concealment, and accountability. If the defense successfully challenges critical elements of the case, then the public narrative changes dramatically. That is why the upcoming proceedings are so important. And it leads to the question that transforms this from a legal story into something closer to a thriller. What if the most...
Look, from a legal point of view, I'll just give my 2 cents. Look, I get what he's saying, right? If the prosecution, if he's really innocent, then you would assume that the prosecution's evidence against him is really weak. Put their feet to the fire, have an immediate preliminary hearing, which is kind of what I think the defense initially wanted. We'll challenge the evidence, we'll get him out, that'll be that. But the other way of looking at it is, you know, you got to prepare a proper legal argument, and you need time to look at what the prosecution's evidence is. So how do you see it, whether or not this delay?
Significant evidence in this case has not yet been seen by the public at all? That possibility hangs over every delay, every hearing, every filing, every procedural update. Because when investigators describe massive amounts of digital evidence, the obvious question follows: what remains inside those devices?
All the evidence, but I was hoping we would get a preview. I was hoping we'd get an idea of what we can expect at the preliminary hearing, because this is a case that has been shrouded in secrecy since September of last year. We're looking for bits and pieces of information and evidence. So when this preliminary hearing potentially happens, whether it's in July or it's pushed off, what are you looking out for? Are you going to be saying, you know what, Jesse? I really want to see the actual substance, the actual content of the text messages between Celeste and David, not just the descriptions of them by prosecutors. I want to know more of the explanation of that Santa Barbara trip. Jesse, I want to see the surveillance video of David allegedly driving the Tesla. How about this? How exactly are prosecutors going to prove that they know that he watched her bleed out in his home? Is there surveillance? Is there an eyewitness? What about the DNA and the forensics? You know, there's a part in one of the prosecution's filings where they say inside the garage, detectives discovered evidence consistent with the dismemberment of the victim's body in the inflatable pool, which contained multiple linear cuts, several biological samples.
Especially when the stakes are this high. And the stakes are extraordinarily high. The charges themselves are severe. The allegations are severe. The potential consequences are severe, which means every procedural decision becomes magnified. Every filing matters. Every motion matters. Every scheduling change matters. Not because it determines the outcome, but because it reveals where the battle is being fought. Right now, that battle appears to be occurring inside discovery, inside evidence review, inside preparation, not inside public arguments. And that may explain why so many observers left this latest hearing with more questions than answers. The court moved the schedule. The attorneys adjusted their timelines. The case advanced another step. Yet the central mystery remains unchanged. What evidence will prosecutors...
Witnesses before agreeing to a status conference timeline. They did eventually settle on that July 7th date, but yeah, I'm curious about all of that because the wording in that preliminary brief is so interesting. Prosecutors state so much of that as facts, which obviously raises the question, well, how do you know? How do you know the defendant stood by and watched his victim bleed out? I mean, two options come to mind immediately for me. Either there was a witness who is claiming that, or there must be surveillance video. And yes, absolutely, I am curious about the text message exchanges between David and Celeste. We have all read now the descriptions of those text messages, how some of them have made reference to things like Plan B, abortion, pregnancy, sexual activity between the two. We have not actually read those messages. I'm also curious about the final argument the two of them had, the one that went on before David allegedly ordered an Uber that brought Celeste from her family's home in Lake Elsinore, more than 80 miles away, to his rental home in the Hollywood Hills before her phone went dead and she went missing. So there's so...
Actually placed before a judge when the preliminary hearing finally begins? Because that moment changes
but it usually be like the lead detective to kind of summarize everything that they have. But also you have to think about this, right? The conversation that David allegedly had with Celeste to allegedly lure her there, that goes not only to the idea of motive, that goes to the special circumstances, lying in wait, killing a witness for financial gain. She had to have said, I'm going to ruin.
Follow the evidence. Now let's talk about another contradiction. Normally, people associate confidence with speed. If you're innocent, move quickly. If you're right, move quickly. If the evidence favors you, move quickly. But experienced defense attorneys often operate differently. They want every document, every report, every forensic result, every witness statement, every digital record, every possible inconsistency. Not because delay guarantees success, because preparation is strategy.
And as a witness, to add color, to add dimension.
Yeah, and look, a couple of things there, right? So in a preliminary hearing, you would imagine it's not all the prosecution's evidence that they have, and sure, they get more evidence as they go to trial, but it usually be like the lead detective to kind of
attentive, comfortable, even smiling at points.
Advantage to David and his defense team.
I think there is so much evidence against the defendant here, Jesse. I don't really know if there's any kind of advantage for his case. I hate to let what's happening in the court of public opinion, leak into what's actually happening in the courtroom, but it is an undeniable fact that there is overwhelming evidence against David Anthony Burke here. Otherwise, prosecutors would not have brought this case. Now, there are questions as to why there was no grand jury indictment, but we have seen the 9-page preliminary brief now, the charging document, if you will, laying out what the prosecution's side of this is going to look and sound like in courts. And even some of that material that can't be presented to the court, they've described what that is, and that's part of that 40-plus terabyte volume of data.
The process. A preliminary hearing is not a trial. It's not about guilt. It's not about innocence. It's about probable cause. In plain English, prosecutors must demonstrate enough evidence for the case to move forward. That's it. A lower threshold, but still an important one, because for the first time, portions of the evidence
that was dumped during discovery on the defense. Now, from the attorney's standpoint, I understand the more time they have, right, the more options they can consider, the more research they can do. From David's standpoint, from the defendant's standpoint, he's the one sitting in jail. I don't know how much longer he really wants to be there. Again, he did not look good this morning. He clearly has not been sleeping well behind bars. So his attorneys, his team, probably sold this to him hard. The more time we have, the more we can look into this, and this, and build a stronger case for you. Because he's not just facing one felony charge. This is not just a murder case. He's accused of 3 separate felonies. One of those felonies has special circumstances that make him eligible for the death penalty, even though executions have been halted here in the state of California since 2019. It is still legal for the death penalty to be a sentence considered by prosecutors, so there's still a question.
The water. It's raising the pressure. And according to prosecutors, that reservoir now includes forensic evidence, digital records, witness testimony, biological samples, and tens of terabytes of material still being reviewed. Before we go deeper into what the documents actually show, make sure you're subscribed to Audit the Case, because we don't just cover the story, we follow the evidence. Now, let's start with the simple question. What actually happened?
Looking out for, what do you want to see in this case?
I'm looking for all of that, Jesse, and in addition, I'm curious about who the prosecution is going to call as a witness Now, the DA brought that up this morning. The prosecution brought that up this morning. They said they had to check with detectives. They had to check with their witnesses before agreeing to a status conference timeline. They did eventually settle on that July 7th date. But yeah, I'm curious about all of that because the wording in that preliminary brief is so interesting. Prosecutors state so much of that as facts, which